Good morning, Mr. Warboys.
Good morning. I'm here today representing the defendant in the case underneath and the appellant to the case today, David Donovan. This case began on June 7, 2006, when the plaintiff in the case below and the appellee here today, Ms. Caplan, filed a complaint for protection from abuse in the district court, which alleged acts of abuse going back 2.5 years, and detailing the most recent single act of abuse as an affidavit filed therewith, thereby saying that the acts of abuse commenced sometime in late 2003, early 2004. There was an ex parte hearing 2 days later, on June 9, 2006, where Ms. Caplan testified that she had arrived in Massachusetts the Monday of that week, that was June 5, 2006, and requested her address to be impounded. She said that Mr. Donovan did not know that she had come to Massachusetts, but that he had been calling her mobile phone 5 or 6 times a day. An abuse prevention order did enter that day with an expiration date of June 19, 2006, and the hearing was scheduled the same day to see if the order should be extended. 4 days later, Mr. Donovan was served with this abuse prevention order in his home state of Florida. He was not able to make it to Massachusetts, and so he retained my firm to represent him at that hearing, where we filed a motion to dismiss pursuant to Civil Rule Procedure 12b-2, lack of personal jurisdiction over him concerning this matter. At that hearing, it was further established that Mr. Donovan had met Ms. Caplan in 2000 in Massachusetts, and that the two of them actually lived with Mr. Donovan's wife for 2 years in Massachusetts before the three of them moved to Florida in September of 2002. In those proceedings, we relied heavily on a case called LaMarche v. Lucier, which was an appeals court case from 2006. The district court found it, decided to take the matter under advisement, but said on the merits, because the court had heard from Ms. Caplan twice, found her to be credible, and all Mr. Donovan had was an affidavit, said that if the court found that it did have jurisdiction to extend the order, that it would do so. And it did deny the motion to dismiss, holding LaMarche v. Lucier is not on point. In LaMarche, the defendant had not lived in the Commonwealth. Here, the defendant lived with the plaintiff for 2 years in the Commonwealth. The problem with that decision is that that is not a minimum contact under the International Shoe Standard that should be considered as to whether or not personal jurisdiction may...
Your adversary points to some language in 209A itself that seems to confer, she argues, out-of-state jurisdiction. Are you familiar with that?
I am.
What do you say about that?
Well, that has to do with the venue, which really has nothing to do with jurisdiction. 209A does say that any court in the Commonwealth may have venue where the complainant resides, but venue and jurisdiction have absolutely nothing to do with each other. That it doesn't really say there's any jurisdictional language, and so you have to look to the long-arm statute.
What do you say to the, in the Lucier case, to the last, I guess it's the last footnote, the discussion about the Iowa and New Jersey cases and, regulating the status of this plaintiff, that is, protecting this plaintiff who is before the court?
Well, with all due respect to the high courts of Iowa and New Jersey, the International Shoe held, it said that any order imposing a personal obligation or duty always creates due process concerns.
Well, what's the obligation or duty here?
Well, there's several. That the obvious one here is basically telling him, don't contact Ms. Caplan, don't contact the child. But it actually went
it's not an affirmative duty, though. I mean, his property isn't at stake. It's not susceptible to being levied upon. He's not being ordered to pay any money. He's not being told to stay out of Massachusetts. What he's essentially being told is, it seems to me, that if you do come into Massachusetts, she will be protected. And if you do contact her and do certain acts, which you're prohibited from doing under this order, you could be responsible for criminal sanctions.
Right, but that presupposes that there would still have to be that at least that hint of jurisdiction to make that order in the first place.
What if that hint comes from the fact that she either testified, I guess, that he had done certain things that reached her in Massachusetts, telephone contacts, that kind of thing, which occurred in Massachusetts?
Well, actually, we don't know that, Your Honor.
Well, what did she say happened?
What she said was that he had been calling her mobile phone, a cell phone.
In Massachusetts?
No. She said he'd been calling her 5 or 6 times a day. However, the last incident of abuse was May 14th, 2006.
No. No, harassing telephone calls can constitute abuse. So when was she, 5 or 6 times a day, and for how long had she been in Massachusetts?
Well, it doesn't say when she actually received the telephone calls. That
She
she had
says
been in
5 to
Massachusetts for 2 days.
Right.
But but the last incident of abuse was May 14th.
But, I mean,
No.
can't you infer reasonably, given that he was also calling her relatives or friends trying to find her, that those calls she was referring to were made to her while she was in Massachusetts?
Well, obviously the calls going to her relatives and friends weren't being made to her.
No, but
But
my point is, he's calling the relatives and friends in Massachusetts. She says, I'm getting calls 5 or 6 times a day. I mean, the reasonable inference to draw is that she is receiving those calls in the 4 days or whatever that she had been in Massachusetts.
And if that's so, there's your jurisdiction.
But even assuming that is the case, that she was in Massachusetts when these phone calls were being made, how is it that Mr. Donovan was affirmatively reaching out to Massachusetts when it's established he didn't know where she was? That the standard is, again, under International Shoe, under Burger King Corp., that what happens is the personal
Isn't that
jurisdiction...
a risk he takes? I mean, let's assume she was in Connecticut. By placing these calls, if we can infer on this record that these calls were coming into wherever she was, and Connecticut would have jurisdiction over him to enter an order too.
Well,
I
suppose...
mean, isn't he taking that risk that wherever these calls end up, if that state has a domestic abuse law, I mean, I know he's not thinking this, but if they do, I may be subjecting myself to jurisdiction by doing this. This is not like someone sending catalogs about, buy shoes or
Well,
calling.
let's, even beyond that, let's say that he did assume a risk, that he had some sort of knowledge, some sort of constructive knowledge that she could have been in Massachusetts. The problem is the record also doesn't say what, if anything, was said.
Well, I thought I'd say first of all, the defendant presumably knew that Ms. Caplan's mother lived in Massachusetts, right?
That is correct.
And there's testimony from her that he was calling her cell phone about 5 or 6 times a day, and that he's been calling friends of his in Massachusetts to call me and find that information from me for him. Isn't there a reasonable inference from that he assumed that she was in Massachusetts? Why would you be calling friends in Massachusetts?
Well, she could have had friends in Connecticut, for example.
That's not whom. There's no evidence that your client was calling his friends in Connecticut. There's evidence that he was calling friends in Massachusetts, presumably because he understood that she was in Massachusetts or was likely in Massachusetts.
Well, I would say that the record actually says that he was calling these people to find out where she was, presumably. But just because somebody lives in Massachusetts doesn't completely take it away the knowledge that they might be somewhere else.
Do we know
calling
her cell
father.
phone number?
The cell phone number?
Is it in the record?
No, I don't know what the cell phone number is.
Do
in the
you
record.
concede that phone calls are enough to establish jurisdiction?
Well, no, and the reason is because I would say that it doesn't give rise to the complaint for abuse. That in the absence of any knowledge of what was said, or if even anything was said, that it was just phone calls, it's not abuse under the statute, and the complaint...
Maybe in and of itself it may not be abuse, but in light of the extremely serious claims made by this woman against your client, she is under oath. Many 209A orders are issued ex parte because they are such emergency orders. I don't think the judge is required not to take that into account.
To take the phone calls into account?
Well, to view the phone calls in isolation from the prior history of what had caused her to return to Massachusetts and why she is in fear of, why she needs a restraining order.
Well, abuse is the definition, 209A Section 1, has really 3 things that can be considered abuse. One is causing physical harm. Another is, attempting to intimidate someone into a sexual act. And the third one is putting someone in imminent fear of harm. Now, that has been interpreted to be the same as common law assault. Be put in apprehension of fear of harm. But I don't see how a phone call from across the continent
Yeah, but now you're
Well,
arguing,
the issue really is jurisdiction.
yeah, you're arguing a different
You're
ground
arguing the
now.
merits here. The issue is jurisdiction, and I take it you would distinguish this case from the New Hampshire case, in which the person received 40 phone calls a day of a threatening nature.
That's right, because there in the record, there was something saying that
There was
this-
harm in New Hampshire. That, the court said, that's harm in New Hampshire.
Correct, and that's actually, and that's what the Supreme Court has said, that what happens is that if you look at what the contacts with the forum state are, they have to be the contacts that give rise to the substantive legal dispute. That in this case, I would suggest that just simply receiving phone calls without any evidence of what was said and given the definition of abuse, that in filing a complaint for protection from abuse, it doesn't qualify as a contact that can be considered constitutionally under the minimum contact standard.
Unless that contact causes harm in the state, and then you look further beyond that.
Well, that's actually interesting. The acts that, if you look at the long arm statute, that is one thing that's in dispute. Section 3D, which talks about
3D, is that what you said?
Yes,
Yes.
3 delta. That there were acts of abuse that he caused some sort of harm in Massachusetts by an act or omission outside of Massachusetts. But when the legislature crafted the long arm statute, it obviously intended to create a constitutional statute. And when you look at the long arm statute, you can see these Supreme Court cases, how they're interpreting it. And 3D is really coming right from the Helicopteros Nacionales case, which basically distinguished specific special personal jurisdiction from general. The general personal jurisdiction are the continuous systematic business contacts with a foreign state, basically saying that, for example, a corporation that may be incorporated in one state, have a primary place of business in another, could have such massive contacts with another state that even though it's a non-resident, maybe considered non-present, due process is not really implicated. But there's nothing in the record that suggests that Mr. Donovan had any sort of persistent course of conduct with the Commonwealth. So I would suggest that 3D is wholly inapplicable to this case.
Yeah, I'm actually really talking about New Hampshire's analysis of it. The fact that there was harm in the state resulting from contacts with the state. They looked very much at the specific jurisdictional components and conclude, which are constitutional questions, not
Correct.
necessarily questions in our long-arm statute.
That's right. I don't know what New Hampshire's long-arm statute is. But the Massachusetts long-arm statute has been interpreted to stretch to the constitutional limit.
Yep.
And so that's why I'm focusing largely on the constitutional arguments.
Would you agree that at least for child custody purposes, and I understand that's not, the ultimate order didn't deal with that, but under the Uniform Act, that on these facts, Massachusetts would have jurisdiction to deal with custody questions?
I don't think UFSA is applicable to this case at all. But I would say the answer is no. And the reason for that is for the same sort of minimum contacts analysis, that clearly the existence of the child is what would be that minimum contact. But the child was not born until February of 2004, and they went to Florida in September of 2002. So I'm not sure how you could say that somehow that the child's existence has some sort of a nexus.
But the child is here. The child is here.
I'm looking at what's quoted, and again, in that Lussier case, it says that the statute would say that Massachusetts court can award temporary emergency custody of a child to a parent fleeing to Massachusetts from an allegedly abusive situation in another state.
Well, there are two distinctions to be drawn. One is awarding custody is probably well within the kind of sort of quasi-in rem powers of the state. That goes back to Penoyer versus Neff. I don't think that's really in dispute at all. But the problem is ordering further affirmative relief beyond custody is where it gets dicey.
But if all that's doing is a protective order, why is that further affirmative relief?
Well, it's because what 209A can do, that the district court in a 209A order could have, well, and one thing that did happen is he actually did have to surrender his property.
Well, I appreciate that, but if the order were purely protective, you can't contact, you can't abuse, you have to refrain from those acts, which is how it gets expressed. That's protective, isn't it?
But those are still orders being directed towards Mr. Donovan in Florida. That Ms. Caplan didn't get something from the district court saying you are hereby protected. He got an order in Florida saying don't do this, don't do that. That although it might be a sort of de minimis personal obligation or duty, it still is an obligation not to do something, and it does affect a liberty interest. that this is a child that he did raise as his own for 2 years, and now to be told, don't contact the child.
Well, he can always apply for some kind of relief in the probate court, try to establish some visitation. He can do that. The 209A order doesn't foreclose that.
No, it doesn't foreclose that, but just the very existence of the 209A order triggers that due process concern.
Well, the question is he required to come into Massachusetts to petition the probate court as to whether or not he should be able to have visitation rights? He's in Florida.
That's
right?
That's
I mean,
a very
he can come in to try to, he can attempt to be relieved from so much of the order as prevents him from having access to his child. But the question is, can we force him to do that in Massachusetts where he doesn't reside?
Well, the fact that he would have an avenue of relief to abrogate what would otherwise be an unconstitutional order, it doesn't change the fact that that order should not have entered in the first place. I know that's not exactly responsive.
I'm trying to help you, Mr. Warboys. It is, of course, he can try and be relieved from the order, but why does he have to come here to do that when it's his child who is being taken? In any case, your time is up, Mr. Warboys.
Thank you very much.
Thank you. Ms. Quillian?
Good morning. Pauline Curian for the appellee, Ariana Caplan, and with me is Megan Christopher. What is at stake in this case is the ability of our courts to protect victims of domestic violence who flee from other jurisdictions. Protection from domestic violence is a human right. It's been characterized as a condition of civilized society, as this court stated in Custody of Vaughn.
I take it we can infer that all these calls came to her in Massachusetts.
Yes, Your Honor. The transcript on page 13, there's a question from the court. It says, has he, and then it has the word inaudible. It says, with you since you've been back. We can infer that means
contacted you.
Yes.
We cannot infer, I think, that she is asking, the judge is asking, has he threatened you?
Well, in this context, what the transcript does indicate is he was calling her 5 or 6 times per day.
I understand that. Is there any evidence in the record as to what the content of those calls is?
There's no evidence in the record as to the contents of the calls, but you have to look at the calls in the context of domestic violence. A telephone call is not just a telephone call when there's been a history of domestic violence.
Well, it may or may not be. I mean, she's left with his child. Obviously, this is a rocky relationship. He wants to know where she is.
He wants to
what
know
can
where
we do?
his child
what can
is.
I'm sorry. Who knows? That's the whole point. Nobody knows.
Well, again, going back to the history of domestic violence, I think as the court said in the AR case, AR versus MR, it characterized telephone calls made in the context of domestic violence as tantamount to a defendant's physical
Quillian,
pursuit of the victim here.
Let me interrupt you. What would be most helpful, and I know that Mr. Warboys did the same thing, is that we not focus on whether or not, in the context of this case, receiving telephone calls could be considered as the grounds for issuing an abuse protective order. Leave that question aside. In other words, if the court has jurisdiction over the person, it is perfectly permissible for the judge to ask what I infer was a contact question. Has he attempted to contact you? In other words, you talked about abuse before. Has there been some attempt to contact you? Because the essence of a 209A order is a no contact, and contact can be by telephone. Fine. The issue here is jurisdiction. And we have a statute, we have a long-arm statute, and the question, what makes this difference, at least one thing that makes this different from the McNair case in New Hampshire, is that there was evidence that he had telephoned her and threatened her, right? And so the court concludes she's in New Hampshire, he is committing a tort, and she's in New Hampshire.
Causing harm in New Hampshire.
Causing harm in New Hampshire. Let's assume that what the court has here is a woman, and she has with her this man's child. And what he is doing is telephoning to find out where she is because he wants access to his child. Right? But the issue here is not an order pertaining specifically to the child. The issue is he cannot get. So, what's the basis of the jurisdiction?
Well, I think there are two ways that this court can get jurisdiction over an out-of-state defendant. It's relevant as to whether there are any remedies available. The Defendant's Counsel relied heavily on the Colco case, but this case is very different. In Colco, the Supreme Court specifically stated that there was a public policy that they were trying to promote in terms of getting parents to agree around children and cooperate with each other. And Colco also noted that Mrs. Colco had available a remedy to her through the ERISA process, the interstate process.
Let me ask you the question this way. She comes into court, okay? She flees. I'm not minimizing the conduct here. She flees. She's in fear of her life. She comes back to Massachusetts and likely goes to live with her mother, right? And let's assume that he doesn't make any telephone calls to her. Makes no telephone calls to her. Calls the mother, saying, do you know where the mother of my child is, where Miss Caplan is? Makes no calls to her. Does the Massachusetts have court to issue a 209A order in that case?
Yes, Your Honor. The court would have the power to issue a 209A order. The limitation would be on the gun surrender order. On the what? On the gun surrender provision that's contained in this protective order. There's a no contact order, there's a no abuse order, there's a stay away order.
Before you get to that, you have to have jurisdiction.
Yes.
Let's assume she comes and and he doesn't telephone anybody. But she knows that he knows where she is most likely to be, and she is in serious fear of her life. Does a Massachusetts court have jurisdiction to issue a 209A order?
I believe that the court does have jurisdiction to issue the protective order. If you look
based on what?
If you look at this court's decision, for example, in Wiley versus Wiley, which was a 1952 case, which was decided after Pennoyer, it was decided after International Shoe, and in that case, this court held that there was jurisdiction to enter an order that the husband refrain from abusing the wife. It held also that there was no jurisdiction to enter a support order, but as to the order that he refrained from interfering with her physical liberty, there was jurisdiction. There is something called status jurisdiction. It's somewhat of a misnomer. It's jurisdiction based on someone being a resident or a domiciliary of Massachusetts. There's a whole line of cases having to do with child custody, and in this case, we advance from 1952 with the Wiley case to the present day. We now have Chapter 209A.
Let me just follow up on that a little bit. If the court does have the authority, does have jurisdiction to enter an order, a 209A order in Massachusetts, is that order enforceable if there's is that order enforceable in a foreign jurisdiction if a violation occurs in a foreign jurisdiction? For instance, if the two happen to meet in Hawaii, and there's an argument in Hawaii, could Ms. Caplan pull out an order and go to the police department in Hawaii and say he's in violation of a Massachusetts order?
If this court, if the jurisdiction is based simply on her being a resident of Massachusetts under full faith and credit under the Violence Against Women Act, you couldn't register the order, for example, in another jurisdiction. So you wouldn't have, because the Violence Against Women Act provides that you have to have jurisdiction over the parties to register that order in that other state. However, the order would certainly be good in Massachusetts, and it triggers numerous protections for Ms. Caplan, such as mandatory arrest should he violate the order. And clearly she's entitled to relief under Chapter 209A, and it is important that in his brief he does concede he did make the phone calls to her And there was really nothing in the record below to refute that he abused her. I mean, there was no testimony that he offered. What we had was her testimony and her affidavit.
Are you
wait a minute.
basically conceding that any order issued by the court here would not be void, or would be void to the extent that it compelled him to do things in Florida, like surrender his guns and things of that sort?
Well, I think an order taking away his property would be problematic. I think the court below didn't address child support. There's an independent basis for jurisdiction if you cause a child to come to the Commonwealth as a result of your acts and directives.
That's the uniform law, right?
Yes. And I think that while the uniform law perhaps isn't on point because she didn't actually obtain a child support order, it is telling about the evolution of the concept of jurisdiction, because all the states in the country adopt UIFSA, which provides that when you commit acts or directives causing someone to go to another state, that by itself is a minimum contact.
Ms. Quillian, you know in this case that was not the basis of the judge's decision. The judge concluded that the basis of the judge's denying the motion to dismiss, which challenged the jurisdiction, was that Mr. Donovan had lived, it's a little hard for me to read, that was both, here the defendant lived with the plaintiff for 2 years in the Commonwealth.
Well, I think that this court can affirm the order below on other grounds. In addition, it was relevant that he used to live here. It goes to contacts he had with Massachusetts. He met
Can
the
I just
plaintiff.
go back to
could we
another
stop?
claim that you made? Did you want to ask that?
Yeah, I did. I'm just curious. How far back would you say one could go in terms of a person had lived in Massachusetts at one point in time? In our case, we're talking about 2 years, but what about 20 years before? If someone had lived here before, would you take the same position?
I think every case is going to turn on its facts, so it's going to depend on whether somebody, for example, you could have a victim who went into hiding and was in a witness protection program, and the person may be very, very dangerous, and then they're released from jail, and somehow they find the person's address, and they indicated 20 years ago that as soon as they got out of jail, they were going to come out and kill you. So, I mean, the facts are going to vary depending on the particular circumstances.
I take it, Ms. Quillian, I just want to deal with a side point. You said there was no evidence that, that he didn't say that he hadn't committed the abuse. Didn't you say that?
No, I said that he concedes that he made the telephone calls in his brief. And in terms of even the argument that
I just want to make sure that I understand your position. It's your position, as far as I can understand it, that when a party comes before a court ex parte in Massachusetts and says, I have been the victim of abuse in another state, in this case Florida, and I have come home to Massachusetts, that as long as the court concludes that the testimony by the complainant, the person seeking the order, is credible, which the court implicitly does in this case, that nothing further is needed to establish jurisdiction over that defendant.
Well, in essence, if the court is entering relief, such as an emergency custody order or no contact order or no abuse order or a stay-away order, the only time that I think you would need the personal jurisdiction would be in terms of taking his property, such as his guns. I don't think that would necessarily preclude the court.
So provided that it was a no-contact order, the court could assert jurisdiction over anybody, no matter where they were living. They could be living in Mexico or Canada or England or Italy or Greece or China, as long as the person seeking the no-contact order, the protective order, credibly claims that she at some point had been the victim of a serious assault or any kind of abusive treatment. That's your position?
Yes, Your Honor.
Okay.
Yes, Your Honor. I also think it's also, getting back to the Kulko case, it's also important as to whether someone has a remedy. In the Kulko case, the case that did turn in large part on the fact that she had another remedy. There's no two-state process where someone can file for a restraining order in Massachusetts and, like the child support situation, get an order in that other state. So it's very dangerous for victims to have to flee. Sometimes it's very dangerous for them just to get out of the situation to begin with. As this court recognized in Champaign, the time after a victim leaves an abusive relationship, is one of the most dangerous. So I think the availability of the remedy is key. The unavailability of another remedy is key here.
Just help me out a little bit. What is the extent, or what is the nature of a no-contact order? Is it anything more than simply a notification that if you do the things that are contained in the notice, and you do them, at least in Massachusetts, you could be susceptible to a criminal complaint? Does it do anything more than that?
It does nothing more than it's a civil order, and
Excuse me, it tells a parent who has a fundamental liberty interest in having contact with their child that they cannot contact their child, doesn't it?
yes, it does. But this court has long exercised.
No, I understand that. So when you say it's nothing more, in other words, it may be that you can't contact for good reason. I'm not suggesting that. I'm not getting to the merits. But when you say it does nothing more than say if you do something, it's not as if you may not have any right to be in touch with somebody else. I mean, maybe you do, maybe you don't. Nobody is suggesting that you cannot come to Massachusetts, for example, so it doesn't impinge on a right to travel. Nobody's suggesting that you can't continue about your work. But I think when you come to contacting children, there is a serious assertion by the state in that case, isn't there?
Yes, there is, but that's also governed by the defendant and the plaintiff have the protections of the UCCJA, which specifically provide for jurisdiction in that matter, which means the court always has the authority to enter orders for care and custody of children, which sometimes
Did
will have an
anybody
effect.
argue that to the judge in this case?
Like this case, like most 209A cases, involved a pro se plaintiff. She represented herself, I think, in terms of, as this court recognized in Frazado, there is more leeway in 209A proceedings because it is a pro se proceeding, and I think it's probably not realistic to expect a pro se litigant to perhaps lay out the facts as neatly as the jurisdiction as had she been represented.
Thank you, Ms. Quillian.
Thank you.
Take a